is necessary and in the public interest.
I call the Honourable Leanne Dalzell.
Mr Speaker, sorry, I wasn't expecting such a short call from the Chair of the Justice and Electoral Select Committee. The reason that I am surprised that it was such a short call is because of the issue that was raised by my colleague, Charles Chauvel, our spokesperson on justice, in relation to information that we understood would be made available to us in the Select Committee in secret, because the regulatory impact statement made it so clear that it was such a difficult piece of information to have in the public arena because of the implications that it could have, and then to find that the answers were given by the Minister for Corrections in another select committee in another context in terms of the financial review, and we were denied access to that information at the select committee. Now, I would have thought that the Chair would have liked to have taken an opportunity to respond to that, and I'm sure when we get to the committee stages, the Minister, of course, will be asked that question, and it may be in his interest to make sure that the Minister is well briefed on the subject. And I just want to quote from the Hansard of my own contribution to the first reading of this, because this was a matter that I raised at the Select Committee meeting itself. And I said, I would like to receive an assurance from the government that the information will be made available in secret to members of the committee, because I think it would be useful for us to understand the context in which we are debating this. I note that the Minister of Justice is nodding her head. I think it is a matter she would be prepared to take on board and consider. Now, the reason that I raised this was due to the statement in the regulatory impact analysis about the issue around potential behaviour management regime claimants. It actually hadn't occurred to me when we were dealing with the first reading of this bill that there were behaviour management regime claimants who had not actually lodged their claims at that point and were sitting back waiting for the sunset clause basically to take effect and to see what happened afterwards, to basically chance their arm. And I just thought that it was fascinating that Charles Chauvel managed to get the information that we were denied at the Select Committee in questions, written questions to the Minister of Corrections in relation to her appearance at the Law and Order Select Committee, which of course is not the committee that was dealing with this particular bill. And I think that we have to be a little bit cautious about decisions that are being made without the relevant information being taken into account. Now, when we look at the regulatory impact analysis, and I dealt with this in the first reading of the bill, it actually was only prepared at very short notice. And I think that the date of it was the 28th of March 2012. Now, given that the knowledge around the expiry of this particular the implementation of the sunset provision was well known ahead of that time, it seems extraordinary to me that the regulatory impact statement was left so late. It actually smacks of having been forgotten, overlooked that there was a requirement to do this level of analysis before introducing even this bill. And I know that having listened to both the Minister and the Chair of the Select Committee, that they think it's just so straightforward that there's no reason to debate any of these matters. But actually, if we are to do our jobs as parliamentarians, I think we have to take notice of these kind of sequencing issues. And so when we look at this particular one, it says this: the Prisoners and Victims Claims Redirecting Prisoner Compensation Amendment Bill was introduced in Parliament on the 13th of October 2011 to give effect to the redirection policy, but did not receive a first reading. Well, just did not receive a first reading doesn't really explain to us why it didn't receive its first reading. And then it goes on to say, and this is the non sequitur, I would call, of this particular regulatory impact analysis. It says there is now insufficient time to progress it through its parliamentary stages before the sunset clauses take effect on 1 July 2012. Well, I mean, you know, of course that is the case, but don't we need a little bit of a better explanation as to why the bill took so long to introduce? I mean, the knowledge around the general election actually occurring in the interim period, you know, it just... Well, I know that he was busy with this interview with Westpac, as the member says, but that's not the point. It is a serious matter, and because what has happened is this, and I just think I should put this on the record of the House again, because obviously it hasn't attracted much attention on that side of the House. This RIS was prepared within a very short time frame, and accordingly, no consultation was undertaken. However, the Ministry informed the Department of Corrections, the Crown Law Office, the Ministry of Foreign Affairs, the Treasury and the Department of the Prime Minister and Cabinet. The public is likely to have an opportunity to comment when a new bill is referred to Select Committee after introduction. Well, actually, the new bill had been referred to Select Committee had been introduced. And so the whole concept of a proper discussion with the public and proper consultation prior to the introduction of this legislation has just simply gone out the window, and the government doesn't seem to think that that is important. So let me go to the actual provisions in the regulatory impact analysis, where it talks about the need to keep certain information secret. Okay, so here it goes. It goes, exact numbers of existing and potential claims by prisoners for compensation are not stated in this RIS because that information, so it's not the amounts, it's the numbers, is legally sensitive. The numbers were available and were taken into account when the impacts of each option were assessed. Well, let's have a look at, I mean, they did say that they did notify the Department of Corrections and the Crown Law Office, so it is surprising that the Corrections Department had no trouble supplying this information to the members of the Select Committee. And so here is this information. It says how many individual claims for compensation by inmates are expected to be paid out or settled in the coming year, specified by the amount sought and reason for the claim, and how does this compare to previous years? It goes settlements are comparable with previous years. There are 19 cases involving compensation claims filed by prisoners or former prisoners, and one of these is the class claim by 71 prisoners or former prisoners. So that one's already on the record. Another 20 similar cases have been identified. So this bill is about 20 cases. That's what this bill is about, 20 cases. The department is likely to seek to settle 4 cases with compensation payments. A settlement offer has already been made in one other case. Another 3 claims involving offenders being managed in the community will also be considered for settlement by way of a compensation payment. If settlement occurs, any compensation is paid to the Ministry of Justice in accordance with the Prisoners and Victims Claims Act 2005, which has to be extended. It has to be extended or replaced because of the situation that we're in now with the sunset taking effect on the 1st of July this year. So I actually think that the government has done a disservice to this House, both in terms of its response to these issues in the first reading, although the Minister did indicate by nodding her head, and she wasn't nodding off, she's not one of those ministers that do that from time to time. She was actually nodding her head, and she was indicating that that information would be made available. I actually went to the point that I'd accepted what the regulatory impact statement had said at face value and that it could be provided in secret, but no. We were not given that information. I raised it at the Select Committee, and we members of the Justice Department weren't aware of or Ministry of Justice weren't aware of the issue, and they were going back to check. We never got that information provided to us, but now we find it's been provided to the Law and Order Committee. I actually think this is not a good process, but we are supporting the passage of the bill for the reasons that my colleague enunciated.
Call David Clendon.
Mr. Speaker, I'm pleased to take the call.